Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. A lot of people have asked me to comment on Bill C-36, which is aimed at dealing with online hate speech. This is going to be a little bit like dancing with a thorn bush because there's a lot of emotional tension involved in these issues, so please be decent to each other in the comments. The concern that this aims to deal with is people going online and spreading hatred and encouraging violence against members of identifiable groups. So that is a strong concern for many Canadians. However, that doesn't necessarily mean that every response to it will necessarily be a good idea. In particular, we see that government often has responses to these sorts of strong, emotional, hot-button issues that are terrible. When we think of, responses to protect children, especially to protect children online, often what they suggest is broad surveillance, which is a bad plan. So it's always worth being skeptical, especially when something sort of gets us and we're like, this is something we got to do something about. It's still worth being skeptical and saying, is this the thing we want to do about it? Or is there maybe a better way to go about it? I'm not going to go through all of Bill C-36. I'm going to look at one particularly controversial or potentially controversial provision in it. And that is bringing back a version of Section 13 of the Canadian Human Rights Act. Let's have a look at what they're doing here. So Section 13 notes, it is a discriminatory practice to communicate or cause to be communicated hate speech by means of the internet or other means of telecommunication in a context in which the hate speech is likely to foment detestation or vilification of an individual or group of individuals on the basis of a prohibited ground of discrimination. So the first thing in terms of unpacking all of this, so we see you've got to communicate something or cause it to be communicated. It's got to be hate speech. It's got to be by means of telecommunication, and it's got to be likely to foment detestation or vilification, and it's got to be on the basis of a prohibited ground of discrimination. So we've got all of these as sort of elements of this offense. Now, we might start with what is hate speech, and they define that. Definition of hate speech. In this section, hate speech means the content of a communication that expresses detestation or vilification of an individual or group of individuals on the basis of a prohibited ground of discrimination, which makes this whole definition here a little bit kind of circular or tangled. You can't communicate stuff that will cause detestation or vilification on the basis of a prohibited ground if it's likely to do those things. Okay. So let's look at the prohibited grounds here. That's in the Canadian Human Rights Act, just so that we understand what we're talking about. And that has prohibited grounds of discrimination, which includes, or which is specified as race, national or ethnic origin, color, religion, age, sex, sexual orientation, gender identity or expression, marital status, family status, genetic characteristics, disability, and conviction for an offense for which a pardon has been granted or in respect of which a record suspension has been ordered. That one might be surprising to a lot of people. So if the government issues a pardon, it actually has provisions that trigger under the Canadian Human Rights Act. So you can't do anything that will cause detestation or vilification on the basis of those prohibited grounds to an individual or a group of individuals. And you might be thinking, well, what happens if I do? Well, the provisions for if they determine that that's something you've done are right here. Complaint substantiated for Section 13. If at the conclusion of an inquiry, the member or panel conducting the inquiry finds that the complaint relating to a discriminatory practice described in Section 13 is substantiated, the member or panel may make one or more of only the following orders. So they can only do these things against the person found to be engaging or to have engaged in the discriminatory practice. A, in order to cease the discriminatory practice, which means stop saying the things you were saying, and take measures in consultation with the Commission on the general purposes of the measures to redress the practice or to prevent the same or a similar practice from recurring. So to redress the practice sounds to me like they may make you issue a retraction or an apology. The language here seems to leave open the possibility of compelled speech, which is going to be constitutionally problematic. However, it goes on to note, an order to pay compensation of not more than $20,000 to any victim personally identified in the communication that constituted the discriminatory practice for any pain and suffering that the victim experienced as a result of that discriminatory practice, so long as that person created or developed, in whole or in part, the hate speech indicated in the complaint. Now, personally identified is unclear here. I'm not sure whether they mean, or ultimately they're going to have to decide whether this means either somebody that you name in particular, Joe Blow, that person is named specifically, or whether it's something that could encompass a wider group. For instance, if you identify, you don't like men and Joe Blow is a man, therefore, he's personally identified. It's not entirely clear. However, this is effectively a bounty system because you can end up having to pay up to $20,000. That's going to create an incentive to potentially launch these complaints. There's also a provision to pay a penalty of not more than $50,000 to the Receiver General if the member or panel considers it appropriate, having regard to the nature, circumstances, extent, and gravity of the discriminatory practice, the willfulness or intent of the person who is engaged or has engaged in the discriminatory practice, any prior discriminatory practices that the person is engaged in, and the person's ability to pay the penalty. So this is basically a fine. They can say, listen, we're going to fine you $50,000, which means that you could be on the hook in total for $70,000. That's a lot of money. And $20,000 may go to the person who made the complaint. So there's an incentive to launch these. There's also a provision here that notes that people have the ability to ask or to have these dealt with privately and with orders that restrict the availability of their name. So non-disclosure of identity, commission. The commission may deal with a complaint in relation to a discriminatory practice described in Section 13 without disclosing to the person against whom the complaint was filed or to any other person the identity of the alleged victim, the individual or group of individuals who's filed the complaint, or any individual who has given evidence or assisted the commission in any way in dealing with the complaint, if the commission considers that there is a real and substantial risk that any of those individuals will be subjected to threats, intimidation, or discrimination. And they can also make an order that if you find out who these people are, that you can't disclose that to anybody. This is a real concern. You might end up facing a complaint and being unable to know who's made the complaint. So let's say I have a YouTube channel and let's say I discuss controversial issues like, say, gun control. And somebody out there doesn't like this. So they go online and they edit up a Twitter thing that says something horrible. And they say, Mr. Runkle posted this online and then he deleted it, but it was seen by a whole lot of people. And, we're filing a complaint on that basis. And I come in and say, I never posted that, but it looks like a real screenshot because it's really easy to fake up a screenshot for something on Twitter. It's dirt simple. I'm not going to point you to how, but it's real easy. Now, it might assist me in defending that complaint to know who it was who made the complaint. Because let's say, for instance, that they're a member of an online gun control group. Or let's say there's somebody with whom I've had many disputes online. I might be able to say, listen, not only did they make it up, but they have a motivation to do so. Look at their group involvement, in terms of being in a gun control group. Look at the past history of our interactions. Maybe look at the past history of, maybe they've got a history of making up complaints. None of those things are things I'll be able to dig into if they decide that their identity should be hidden. So that not only is there a potential financial incentive to make complaints, but you can do so while completely shielded from public scrutiny. There have been many situations where reporters have dug into complaints that have been made and said, listen, this is ridiculous. So this is very concerning. It very much creates a weighted practice. But if you want to use these complaints as a means of fundraising, like if you want to make this your job, well, this is great. I mean, you could have all of these complaints filed and you might be filing a complaint every week and none of these people are going to know that you filed hundreds of these complaints because they can't talk. They can't say, hey, listen, let's compare notes. How come this person is sending out hundreds of these complaints? So yeah, that's a bit of a concern here. They note that it doesn't apply in respect to private communications, and it doesn't apply to internet hosts or that sort of thing. So just because you host speech, so Twitter or Facebook, they're not going to have to worry about this. You're going to have to worry about this in terms of stuff that's posted. There's also a provision here that might be of concern to some people. Continuous communication. It says, for the purposes of subsection 1, a person who communicates or causes to be communicated hate speech continues to do so for as long as the hate speech remains public and the person can remove or block access to it. Now, we've had the internet for a long time, and places like Facebook and Twitter and various other services have been around for a while now. So there's lots of people out there who posted things that are dumb that they did, that they made stupid comments when they were young, and they might be 10 years old at this point. But so long as that's still out there and still something that is publicly available, somebody could find it, you're considered to be saying it right now. So you're going to actually have effectively a positive obligation to go through everything you've ever said on Twitter and everything you've ever said on Facebook and everything you've ever said on any other forum where you can potentially change it and go back and edit it. This is also a bit of a problem because many of us, myself included, have been active on various forums for a long time. I don't know if some of these forums are still in existence. I don't know if I have logins for them. None of this stuff is going to get me in trouble with the Canadian Human Rights Act, but plenty of it is stuff that I don't believe in anymore. Stuff where my views have changed, and I shouldn't be taken as if I was saying it today just because it might be able to be found somewhere in some place I've forgotten about, but could maybe remember the password if I had to. For example, I used to be very stridently in favor of gun control, and I used to argue for more gun control all the time. It was in the course of doing research to support these arguments that I realized that many of my beliefs and assumptions on that issue were wrong, and I changed my views. But if somebody were to find one of these old postings and say, hey, look at what you're saying, it's like, that's not what I'm saying. That's what I was maybe saying 25 years ago before I knew better. And there's plenty of people who are in similar positions with respect to prohibited grounds of discrimination. I actually went looking for a Facebook post I'd seen at one point, and I couldn't find it, so I can't share it with you here. But it was somebody who was using the memories feature and digging up one of their previous posts, and they said, look at what I used to believe. I don't believe this anymore. I was wrong. But they were able to contrast their previous beliefs with their current beliefs and use it to sort of teach and explain why they were wrong, how they'd come to change. And it was quite a moving sort of thing. I was quite moved to see it. But this particular thing would say, hey, listen, you've still got that old post up there. And so it's like you're saying those horrible things today, and we can still hold you accountable for that. I have a bit of an issue with that. Some people may want to leave past posts like that up just so that they can comment on it and they can point out that they have changed as a person, that they don't believe these things anymore. So this is a problem to me. And quite frankly, I think that it's kind of surprising that our government is not a little more sympathetic to this, because we have a leader who did blackface through his 20s and can't tell us how many times he did it. Now, those pictures exist as yearbook photos and fragments of video and so forth. But let's say they were an old Facebook post. Anybody can run into the problem of having been stupid when they were young. We were all dumb when we were young, and some of us got better, and not all of us. But this is a really sort of a weird situation. I don't like the way this legislation is set up. There is hate speech law already built into our criminal code. It is illegal to publish or send out stuff that meets a very high test for hate speech. However, this goes a different way. The normal hate speech legislation, the police do their investigation, they proceed. But this actually is sort of a Wild West kind of system where there's a bounty out and everybody is out to be their own enforcer without any training and without any accountability. It's really going to be a system where people may end up going and digging through each other's old comment histories just to find something with a potential $20,000 prize on it. If we want to envision a I'm having trouble picturing a more potentially divisive way of setting this up than what they're doing. I get what they're trying to accomplish here. There are concerns about violence against many different groups in our society. I don't think this is the way to go. I think that this bill is a real problematic bill, and I think it's going to create a lot of trouble. I think that there's portions of it that should be very concerning. A lot of people, when they think about legislation like this, they also develop a kind of mental image for the person or people that they imagine this affecting. And it's usually not a very flattering mental image. They say, I don't like those kinds of people. I don't have any sympathy for them. This isn't going to affect me or people like me, so go ahead and do it to them. They're bad people, go to town. And that's a dangerous way of thinking because society can change a lot in 10 or 20 years. Things that are considered acceptable or popular even now might be completely unacceptable and shocking then. And you might be held to account for something you say today with today's sort of standards simply because you forgot to delete it or you never thought to. An example I'm going to give is a t-shirt campaign, and I'll see if I can bring it up here. All right, so this was controversial. I'm not going to say it wasn't controversial when it came out. However, nobody that I know of went to, was facing court proceedings over this. But imagine this is something that I could envision society changing and saying, we condemn this. This is aimed at children. This promotes a vilification of a particular protected group, that being boys. And it also directly suggests using violence. So that could be something that if society changes in certain directions might be viewed as shocking and might actually be viewed as sufficient to ground a complaint. So there is that very real risk that some of the people making comments that are blowing off steam today, or, they're expressing their anger over, all sorts of shocking things that happen in the world. Sometimes people don't necessarily communicate the best, and so they may overgeneralize and, so forth. Those things, if society decides later are unacceptable, might end up grounding these complaints in future. So I don't think that this is something where you can say, I'm safe, I'm within the popular zeitgeist right now, because you may find that the sand underneath your feet shifts and you could be on the hook. You may also see people who are upset by things like the boys are stupid, throw rocks at them shirts, and saying, listen, I'm upset about this, and I could potentially get paid $20,000 if I can convince, a commission member that I'm right. Why not bring that? Anyway, this to me is very concerning. I have a lot of worries about it, but there's other stuff in this bill that I don't like as well. I do think that there is a problem here in terms of what's happening with our society, in terms of violence being promoted against various groups, but I don't think that this bill is... I think it's a problem that needs a scalpel, and this is more like throwing dynamite in there. So that's really my concern. Anyway, let me know in the comments section below what you think. As I said, this is a thorn bush of a problem. Please like this video. Please share it with your friends. Please subscribe to see more content. I also have a link to my Patreon below, so if you want, you can help support the channel. I also want to thank my Patreon supporters at this point: Jordan Wheeler, Jason Elliott, Canada's National Farms Association, Kyle Martin, Jean-Guy Toussaint, Ivo Nedev, the CCFR, and the Canadian Shooting Sports Association, all at the $50 level. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Matt Ward, Mark Whittington, Dale Nesbitt, Cameron Johnson, and Andrew Elsich. I also want to thank all of you at the $10 level who will be in the crawl immediately following. Thank you once again for watching, and I hope I've armed you with knowledge.